I think we better get started because we've got quite a bit to get through today. Thank you for joining us for a webinar today on the changes to laws that strengthen child safety in early childhood education and the care sector. I'd like to start by acknowledging the Wurundjeri Woi-wurrung people of the Kulin Nation, traditional custodians of the land on which I am presenting today, and pay my respect to their elders past and present, and those who are joining us today. My name is Patrice Fitzgerald. I'm the Director and Principal Lawyer of Safe Space Legal, and joining me today is our Senior Associate at Safe Space Legal, Casey Murphy.
Hi everyone, lovely to be here.
Over the next 45 minutes or so, we'll be examining the most significant strengthening of child protection requirements in the early childhood education and care sector since the National Quality Framework was established in 2012. These changes affect every approved provider, every service and every person working with children in the ECEC sector across all Australian jurisdictions. The reforms are happening now with staggered implementation that began in September last year and will continue through 2026. The changes bring about binding legal obligations with substantial penalties for non-compliance. And by the end of this session, you should be having a clear understanding of your obligations, the timelines for implementation, and the steps you need to take to ensure compliance. If you have any questions after today's webinar, we probably won't have time, unfortunately, to go through some questions and answers today. But if you do have any questions, you'll see at the end of the slides, we have our contact details. So please feel free to contact us at any time, and hopefully we can provide some support or answers to your questions that you might have after today's session. Before we start, I'll just want to acknowledge that the content I will be discussing today can be quite confronting and distressing, as we will be talking about the abuse of physical, verbal, psychological and abuse of children. Should you at any time feel that the content is overwhelming or distressing, please take a break. You're encouraged to speak with your manager or supervisor at the end of the session to debrief if required, and there are some external numbers up on the screen if needed. So what's on the agenda today? The area of child safety in childcare and the early childhood education sector is getting a lot of focus and undergoing a lot of legislative and regulatory changes. We see it in the media all the time, new reports of children being harmed in the sector. And today we're going to cover the changes to the National Quality Framework and the implementation of the Early Childhood Education Register, new mandatory child safety training requirements, as well as reforms that are specific to state and territory jurisdictions. And we're going to include some key implementation timelines. So it's really important to understand, well, why do these changes matter? And to understand why these reforms are so comprehensive, we need to understand the context. So in 2024, Operation Tenterfield resulted in charges relating to 1,623 child abuse offences in Queensland in the early childhood services. We've seen them in the media. We're all aware of them. It was a decisive turning point for the sector and led to urgent calls for systemic reform. The Commonwealth Government, working with state and territory governments, conducted a comprehensive review of child safety under the National Child Quality Framework, and the findings of the review were published in December 2023. That review, combined with the recommendations from other inquiries, such as the Royal Commission into Institutional Responses to Child Sexual Abuse, has resulted in what we're seeing now, the most significant legislative overhaul in the sector's history. I want to emphasise that this is not just regulatory tweaks. These reforms fundamentally change the legal framework governing early childhood education and care. The staggered implementation timeline means that some requirements are already in force and have been enforced since September 2025, and others are coming into effect over the next 12 months. As legal professionals advising this sector, we're certainly getting lots of questions from clients. So we want to help inform what the services need to be doing and why these changes are taking place. The why is simple. Protecting children is paramount. The what is what we'll cover today. So let me take you through the key pieces of legislation that form the backbone of these reforms, and then I'm going to throw over to Casey, who's going to dive a little bit deeper into what the reforms are. So first, the Early Childhood Legislation Child Safety Amendment Bill 2025. That bill was passed in Parliament in November 2025 and introduces the paramountcy principle. the National Early Childhood Worker Register, and the Inappropriate Conduct Offence Framework. This is the cornerstone of the legislation that you need to be aware of. Second, amendments to the Education and Care Services national regulations commenced on the 1st of September 2025. These amendments introduced mandatory digital technology policies, shortened reporting timeframes to 24 hours for physical and sexual abuse, and added in the prohibition of vaping on service premises. Third, the National Quality Standard Amendments commenced on the 1st of January 2026. Now, these refinements to quality areas 2 and 7 explicitly embed child safety into the assessment framework. Element 2.2.3 is now specifically titled Child Safety. Fourth, the Early Childhood Education and Care Strengthening Regulation Bill 2025 passed on the 28th of November 2025, and that gives government powers to gather cost of delivery information and mandate direct gap fee collection for family daycare and in-home care from the 1st of January 2026. So these are the Commonwealth laws, but remember each state and territory also has its own additional requirements, which we'll also discuss shortly. I'm now going to hand over to Casey, who will discuss the reforms and new laws in greater detail.
Thanks so much, Patrice. So the passing of the Early Childhood Legislation Amendment Child Safety Bill 2025, which Patrice has just been speaking about, has amended the Education and Care Services national law to now explicitly state that the safety, rights and best interests of children is the paramount consideration in the operation of education and care services. Now, some of you might be thinking, well, wasn't child safety already important? And of course it was, but paramount is a specific legal term. It means that child safety must be the primary overriding consideration, not one of several competing considerations. So in practical terms, this creates a higher standard of care and more stringent duty on providers. So when making any decisions, whether it's about staffing, premises, policies, procedures, equipment, or operations, the safety, rights, and best interests of children must always come first. Matters such as financial considerations, operational convenience, staffing challenges all come secondary to child safety. This consideration will also inform how courts and regulatory authorities interpret obligations and assess compliance. If a provider argues that they couldn't comply due to some cost or staffing issue, the response is likely to be child safety is paramount. This is enshrined in the Education and Care Services national law. So from a risk management perspective, this means that services need to document that they have explicitly considered child safety as the paramount factor in all material decisions and operations. But what are the practical implications? These include that all policy decisions must prioritise child safety above operational convenience. Financial considerations are secondary to safety requirements. Provider obligations are now explicitly child-focused, and this then creates a higher standard of care and duty. The National Early Childhood Worker Register represents a fundamental shift in workplace monitoring and accountability. For the first time, there will be a single national register that gives regulatory authorities visibility of who is working in the early childhood sector and where they are working. So who must be registered? The answer is simple: everyone. Educators and teachers, regardless of whether they're separately registered with a teaching authority, volunteers, students, non-education staff, nominated supervisors, coordinators, and family daycare educator assistants. Even if they work in or volunteer at an ECEC service, they must be on the register. The provider obligations are critical. Approved providers must enter and maintain workforce information on the register. This information must be kept current and accurate. Regulatory authorities will have access to this information in real time. So why does this matter? I'll give you an example. Currently, if an educator is found to have engaged in misconduct in New South Wales and leaves the sector, there's no effective mechanism to prevent them from moving to Queensland or Victoria and obtaining employment in another service. The National Register aims to close this loophole. When the register identifies that a person has a prior misconduct finding, prohibition notice, or negative working with children check in any jurisdiction, regulatory authorities across Australia will be alerted. This enables real-time cross-border coordination to protect children. This is not optional. It's a mandatory requirement under the national law amendments. The register is currently operational and is being updated daily to ensure that up-to-date data is encompassed. Mandatory registration on the register began on the 27th of February 2026. In addition to the register, digital technology policies became mandatory on the 1st of September 2025. That means if you don't already have compliant policies, you're currently in breach of Regulation 168A of the Education and Care Services National Regulations. These policies must address 5 key elements. First, the use of digital devices by children. Second, the use of service issued or service owned devices. Third, the taking, use, storage and destruction of images and videos of children. Fourth, obtaining parental permission and authorisation. And fifth, the use of optical surveillance devices, such as CCTV. Now, the critical change for centre-based services is that personal devices are prohibited when working directly with children. This means that an educator cannot have their personal mobile phone, tablet or smartwatch with them while supervising children. And this prohibition is absolute. The only devices permitted for taking images or videos of children are service issued or service authorised devices. This ensures accountability and traceability. The National Model Code Taking Images in Early Childhood and Education and Care, which was published by ASIQA in July 2024, provides detailed guidance on implementing these requirements. While the Model Code itself is voluntary, it represents best practice and should inform your service's policy development. For family daycare, the rules are different given the home-based nature of the service, but policies must still address device use and image taking. In addition, we now also have enhanced reporting obligation, which is a critical compliance change that your service must understand clearly. Previously, Regulation 176 of the Education and Childcare Services Regulations approved providers had 7 days to notify the regulatory authority of a relevant event, which includes allegations, complaints, or incidents involving physical or sexual abuse of a child. However, as of the 1st of September 2025, that timeframe has been reduced to 24 hours. Let me be absolutely clear here. Any allegation, any complaint, any incident relating to physical abuse of a child or sexual abuse of a child must be reported to the state or territory regulatory authority within 24 hours. This does not mean within 1 business day, it means 24 hours. And this means that services need robust systems to ensure that if such an allegation is made on, say, a Friday evening, it's reported by Saturday evening. Weekend procedures must be in place. On-call protocols must be established. This is a hard deadline with serious consequences for non-compliance. Additionally, the bill creates a new inappropriate conduct offence. This is conduct a reasonable person would consider to be inappropriate in an education and care service. This expands regulatory reach beyond criminal conduct to capture behaviours that breach professional standards and pose risks to children, even if they don't constitute criminal offences. There's another straightforward amendment to the bill, but it's worth noting as it represents a change from previous practice. As of the 1st of September last year, Regulation 82.3 of the Education and Care Services National Regulations explicitly prohibits vaping devices and vaping substances in education and care settings. So this aligns with existing prohibitions on smoking and brings the regulations into line with current public health understanding about vaping. So while this may seem minor compared to other reforms we're discussing, it's a compliance obligation nonetheless. Services therefore need to update their smoke-free environment policies to include vaping, ensure all staff and visitors are aware of the prohibition, and display appropriate signage. The penalty for breach is the same as for smoking-related offences, and it's $2,000 per fine. The National Quality Standard Amendments took effect on the 1st of January 2026. So these are current requirements. Quality Area 2 is Children's Health and Safety, and this has element 2.2.3 renamed to Child Safety. This is more than cosmetic. It signals that child safety is now an explicit, standalone element in quality assessment. Quality Area 7, Governance and Leadership, has had its wording revised to explicitly embed child safety into governance expectations. Regulatory authorities will now assess whether governance structures, policies, and leadership actively promote and maintain child-safe cultures. So what's the practical impact? ASIQA released an updated guide to the National Quality Framework in January 2026. This guide contains new and additional examples of how services can demonstrate child-safe practices during assessment and rating. It also includes new content specifically on children's online safety. Services that are preparing for assessment and rating or that are seeking to improve their ratings need to review this updated guidance carefully. The assessment criteria have evolved. The quality standard refinements also interact with the paramount principle. When assessors evaluate governance and leadership, they will be looking at whether child safety is genuinely paramount in the service's operations. So going back now to the changes to the national law, I want to raise that in addition to the amendments that I've already spoken about, there are some further significant amendments. This is a significant change to limitation periods, and it has retrospective application. Under the previous law, the regulatory authority had 2 years from the date an offence was committed to commence prosecution. Under the new law, the limitation period is 2 years from when the regulatory authority becomes aware of the offence. This may seem like a technical change, but the implications are substantial. If an offence occurred in 2023, but the regulatory authority only discovers it in 2026, they now have until 2028 to commence proceedings. Under the old law, the time would have expired in 2025. Additionally, if another entity is investigating the same conduct under a different act, for example, if police are investigating potential criminal charges, the regulatory authority can pause the limitation period. Once the other investigation is finalised, the authority has a fresh 2 years to commence proceedings. This applies retrospectively, meaning it can revive prosecution capacity for matters that might previously have been statute barred. The commencement date was 10 December 2025, and for services, this means historical non-compliance may remain actionable for longer than previously thought. Document retention becomes even more critical. So all staff, volunteers and students working in early childhood education and care services will be required to complete mandatory child safety and child protection training. The Reforming Early Childhood Safety Program, known as REX, is rolling out through 2025 and 2026 in partnership with ASEQA. This is an education and training program specifically focused on the national child safety reforms we're discussing today. So while the exact content of the mandatory training is still being finalised, we can anticipate that it will cover recognising signs of abuse and neglect, understanding grooming behaviours, mandatory reporting obligations and procedures, creating and maintaining child-safe cultures, responding appropriately when children disclose abuse, and understanding the paramount principle and how it applies in practice. So the practical challenge is that services may need to close temporarily to ensure all staff complete the mandatory training. This has workforce and business continuity implications. So my advice to services would be to start planning now for how you will deliver this training to your entire workforce, including casual staff and volunteers.
Tracy, I might just interrupt you there because it's my understanding that that's actually now live, the training. So we have it's just been recently announced that the foundation training. So for everyone who is here and is required to do that mandatory training, the foundation training is now available on the education.gov.au website. So please click into that. It's available on Gecko. And there is advanced training coming in from July 2026. So just to be aware, when we prepared these slides, that wasn't quite ready yet, but they are certainly ready now. So we just wanted to touch base on that.
Fantastic. Thanks very much, Patrice. Thanks for clarifying that. So the Early Childhood Education and Care Strengthening Regulation Bill, which passed Parliament in November 2025, introduces new financial transparency measures. The Commonwealth Government now has power to require providers to share information about the cost of delivering early childhood education and care. And this supports the Early Education Service Delivery Prices Project, which is examining the true cost structure of ECEC provision. The government can also share or publicly disclose information about providers that's already publicly available through ASIC or ABN registers. And this will increase transparency about corporate structures and ownership. Strong protections remain for information about children and parents. This transparency is about provider operations, not about the families using the services. The second major change relates to gap-free collection. So from the 1st of January this year, family daycare and in-home care providers must collect gap fees directly from families. Educators can no longer collect gap fees on behalf of providers. This requirement was originally scheduled for 2024, but was deferred to this year based on sector feedback, requesting more transition time. So for FDC and IHC providers, this requires implementing new financial systems and parent communication processes. If services operate these service types and haven't yet implemented direct gap fee collection, they have a compliance deadline that's already passed. Penalties for serious breaches of childcare regulations have increased substantially. As I've mentioned, some jurisdictions have implemented increase of up to 900% for the most serious violations. To give this some perspective, what might previously have been a $10,000 penalty can now be $90,000, and these are not trivial sums. The range of offences subject to penalty infringement notices has also expanded. Regulatory authorities have greater flexibility to issue on-the-spot fines for contraventions without needing to prosecute. Enforcement powers have also been enhanced. Regulatory authorities can now conduct unannounced inspections without requiring consent, exercise expanded information gathering powers, share information with recruitment agencies to prevent unsuitable persons from obtaining employment, publish enforcement actions, creating reputational consequences, suspend or revoke quality ratings, which directly impacts a service's marketability, and impose conditions on provider approval. A new specific offence has been created, which is providing false or misleading information to providers or recruitment agencies about prohibition notices, and this is now a criminal offence. So it means that if a person has been prohibited from working with children and lies about it to gain employment, that's now a distinct criminal offence with increased penalties. So the message is clear. The era of relatively light touch regulation is over. Enforcement is active, penalties are substantial, and regulatory authorities have powerful tools at their disposal. Regulation 115 of the Education and Care Services National Regulations requires that service premises be designed and maintained in a way that facilitates supervision of children at all times. In assessing compliance, consideration should be given to the ages and developmental stages of children being educated and cared for, the size and shape of premises and individual rooms, both indoor and outdoor spaces, and the location of furniture, equipment, and fixtures. Previously, services could apply for a waiver from this regulation if their premises didn't meet the standard, but they had compensating measures in place. However, as part of the recent reforms, service waivers in relation to this regulation have been removed, and there's no longer an exemption pathway. So practically, what does this mean? Services that previously operated under a waiver must now either physically modify their premises to comply with Regulation 115, implement additional supervision measures that are sufficient to meet the regulation without a waiver, and in some cases, they may be required to reconfigure their use of spaces or reduce enrolment numbers. This may require significant financial investment. Walls might need to be removed or relocated. Internal windows may need to be installed, and outdoor areas might need to be redesigned. For services in older buildings or heritage listed properties, this creates particular challenges. Services need to conduct a premises audit now to identify any Regulation 115 compliance issues and develop a remediation plan. New provisions enable regulatory authorities to identify, monitor, and regulate related approved providers. Related providers include providers under common ownership, providers with shared management structures, providers operated by the same corporate group, and providers with overlapping responsible person or directors. So why does this matter? Well, previously, if a corporate group had compliance issues at one service, they could potentially quarantine the reputational and regulatory damage to that specific approved provider entity. And if things got bad enough, they might simply close that entity and continue operating through related entities. These new provisions close that loophole. Regulatory authorities can now track compliance issues across all related entities, identify patterns of non-compliance with corporate groups, apply heightened scrutiny to related providers with poor compliance history, and consider the conduct of related providers when making approval decisions. So this is a transparency and accountability measure. If you advise corporate groups operating multiple services, they need to understand that their entire group structure is now visible to regulators, and poor performance in one entity may impact regulatory treatment of related entities. This also means approved providers cannot simply restructure their way out of accountability. So I've spoken about changes to the national law, and now I'm going to talk about some other significant changes across Australia and in a couple of individual states that are seeing major reform in the child services sectors. The Working with Children Check reforms are one of the most significant developments in cross-jurisdictional child protection in Australian history. On the 14th of November 2025, the Standing Council of Attorneys General agreed to deliver national Working with Children Check reform. The headline is simple but powerful: banned in one, banned in all. By the end of 2025, mutual recognition of negative notices was to be implemented. This means if a person is refused a Working with Children check in one jurisdiction, they will be refused in all jurisdictions. We've already seen this in action in Victoria in a recent VCAT case, where a person who was refused a Working with Children check interstate was found to not have jurisdiction to apply for a review in VCAT, as they had been refused a Working with Children check interstate. This is a significant reform in the Working with Children check system. In relation to the Working with Children check regime, there are 6 priority actions. The first is implementing mutual recognition of negative notices. This is the banned in one, banned in all principle. Second and third, achieving meaningful consistency in an automatic exclusion criteria and risk assessment frameworks. Currently, jurisdictions use different criteria for automatic disqualification and different frameworks for assessing risk. So harmonisation is underway. Fourth, national continuous checking capability. This means near real-time criminal history monitoring. If a Working with Children check holder is charged with a relevant offence, all jurisdictions will be notified promptly. Fifth, enhanced information sharing between jurisdictions, allowing regulators to share relevant information about applicants and clearance holders. Sixth, a consistent approach to screening timeframes to reduce delays and variation. And this results in a person who poses a risk to children not jurisdiction shopping to find employment in the EC sector. So for services, this means that you can have greater confidence in the Working with Children check system, but it also means that you must ensure all workers hold valid clearances for the jurisdiction in which they work. So I'm now going to talk about some state-based obligations that exist in addition to the changes that we've already discussed. Firstly, I'm just going to speak about the reportable conduct schemes that now exist in most states and territories across Australia. Reportable conduct schemes create mandatory reporting and investigation obligations for organisations when allegations of reportable conduct are made against workers. These schemes operate separately from the national law and vary by jurisdiction. So as you'll see up on the screen, there are various states who already have reportable conduct schemes in place. Queensland, who's commencing on the 1st of July 2026, and South Australia and the Northern Territory, who are still developing. Given Queensland's reportable conduct scheme commences in just over 3 months.
3 months, that's not far away.
Gosh, I can't believe we're already at the end of March. Let me give you the detail on what Queensland services need to prepare for. The Child Safe Organisations Act 2024 commences for all sectors, including early childhood, education and care, on the 1st of July. The head of the organisation, who's typically the approved provider or a senior executive, must notify the Queensland Family and Child Commission within 3 business days of becoming aware of an allegation of reportable conduct. An interim report must be provided within 30 business days, and a final investigation report must be submitted as soon as practicable after the investigation is complete. But what is reportable conduct? We have 4 categories, including sexual offences against, with, or in the presence of a child, sexual misconduct, physical violence against a child, and behaviour that causes significant emotional or psychological harm. And we also have significant neglect. Critically, workers is defined broadly. It includes employees, volunteers, contractors, consultants, and people on work experience. It captures both on and off duty if there's a sufficient connection to the organisation. Services need to establish clear internal reporting pathways, train all their staff on the reportable conduct scheme, and designate who will conduct investigations and ensure they have capacity to meet the statutory timeframes. So it's our recommendation that these systems need to be building right now, given that it commences in July. I also just want to briefly go over New South Wales. So New South Wales has laid additional requirements on top of this national framework through the Children, Education and Care Services National Law Application Amendment Act. That's a long name. The Act contains over 30 reforms, and let me highlight a couple of key dates. So from November 2025, all services must display their compliance and quality history at the service entrance using a short form template. As this is already in force, if your New South Wales services aren't displaying this information, then they're in breach. From the 1st of January 2026, the NQS quality area refinements commence. And as we discussed earlier, the penalty regime has changed substantially, and serious breaches now track penalties up to 900% higher than previously. The exact penalty will depend on the nature of the breach, but these increases, as we've mentioned, are significant. In New South Wales, Early Learning Commission has expanded regulatory powers, including the ability to publish compliance histories of high-risk services, suspend or revoke quality ratings in serious cases, and enforce mobile phone photography and CCTV restrictions. Importantly, New South Wales publishes enforcement actions on its website. So prosecutions, suspensions, cancellations, and enforceable undertakings are all publicly disclosed. This creates reputational risk for non-compliant operators. So again, the message to New South Wales services is really clear. Compliance is mandatory, enforcement is active, and consequences are both financial and reputational. I'm going to hand over now to Patrice to talk about implementing the changes.
Thank you, Casey. Casey, that was a lot. I know that there's a lot of changes that are happening in the sector. And I know for those who are listening, it's certainly very overwhelming when all these sorts of changes take place. We've certainly had our clients ask many, many questions yeah, we're here if you need support. So we know about now all the changes that are taking place, and what we thought might be helpful is if we start talking about, well, what can we be doing now as you're implementing these changes? So we're going to go into that a little bit now. So when we talk about the changes, we're going to talk a little bit practically about what services are facing in terms of those implementation changes. So number one, we need to look at policy development. The digital technology policies were required by the 1st of September. So if they're not already in place, that's breach number one. So we want to get those in place. So if you're working in the ECEC sector, I would say that's something that you should be really focusing on and prioritising in order to get those policies up and running. The next thing to have a think about is workforce management. So every single person working at the services must be entered into the National Register. That is a big requirement. We're certainly getting lots of questions from clients about who needs to be entered and under what circumstances. Working with children check information must be current and accurate, and there must be systems to verify working with children check statuses continuously and to notify changes within 24 hours. So it's a significant administrative burden, especially for large providers, but for all providers. So please be aware of that and make sure that you have systems in place to ensure that that's happening. There is some software that has been developed to help with that. So that might be something you might want to look at, especially in those bigger providers. Training requirements. Casey mentioned it before. Mandatory child safety training must be delivered to all staff, volunteers and students. So there's a couple of things to think about in regards to that. Firstly, there's the government funded mandatory training that needs to take place. So as I said before, that's already up and running on Gecko. You can have a look at that on the government's website. And there's also the additional training that will be released from the 1st of July. But it may be that training is not enough for your service. You may want to target specific areas. You might already see red flags that are occurring in your service, and you might want to consider having some tailored training as well. So whether you do that informally in your meetings that you have with your staff, or whether you engage an external provider to come in and understand where the gaps are and help you fill that, training is an excellent way to mitigate risk. The reason is we can't assume that everyone's aware of all their obligations. I think in the ECEC sector, you have such a wide sometimes disparity between people's understanding of child safety in the sector. So it's really, really important to really recognise what those gaps are, train your staff, because that is one of the best ways to mitigate risk to children. One of the other major things that Casey talked about was the changes in relation to the physical changes that are required for services to have Regulation 115 waivers. So premises modifications may be necessary. We know that this can be a huge financial and administrative and physical burden, but it needs to happen. So CCTV installation should be considered, particularly for services with complex layouts. Supervision sight lines may need improvement through physical alterations. We need to make sure that those are already in place, or at least you're working towards that. So please make sure that that's a prioritisation. Now, the financial impact is multifaceted. There's direct compliance costs, there's training expenses, capital expenditure on physical modifications. There's also potential for penalties for non-compliance. So when we look at it from the perspective of, oh, we've got to weigh up all of this, remember that if you don't comply, those significant increases in penalties will hopefully be a good motivator to make sure you do comply. But what's more is remember that paramountcy principle, that child safety is paramount. So you must be ensuring that that is prioritised amongst all others. So your role is to understand the challenges, prioritise them appropriately, remembering that child safety is paramount, and develop systemic implementation plans. So some of the things you might want to do, immediate action steps for providers. We just wanted to try and set out some steps, because what we often find when we work with clients is it can be quite overwhelming and it can be very challenging to work out what do we need to do first. So we thought we'd try and put some steps in place, some priorities in place to help you with that. Priority 1, compliance audit. Review all current policies against the new requirements, identify gaps, particularly in digital technology policies, audit all staff working with children check statuses and expiry dates, creating a tracking spreadsheet or use some other tool to assist you in checking and validating working with children checks. Check your premises are compliant with Regulation 115. The audit should happen now, this week. Set yourself out a task to start looking at that audit. Priority number 2 is policy development. You've audited your policies, you've audited the gaps that exist, and now you need to ensure that the policies reflect those gaps. So draft or update your digital technology policies to meet regulatory requirements, review and revise image taking and device use procedures, establish clear 24-hour reporting procedures with designated personnel and after-hours protocols. Do that now, before something happens, before a critical incident occurs. We know that when critical incidents occur, they are very stressful for all of those involved. You want your systems in place before they take place. So please ensure that that's up and ready to go. If you're in a reportable conduct scheme jurisdiction, develop reportable conduct reporting pathways and have a child-focused system in place as well. So especially flagging for Queensland, where that's going to come in from the 1st of July, once again, prepare now for that implementation, because the reportable conduct scheme does increase your obligations quite dramatically. So make sure you're ready to go. We know that the way in which an organisation responds to allegations of abuse and harm can make all the difference to those who are impacted. It can make all the difference to the child who's experienced a trauma, to their families, to other families within the service, to staff members who've witnessed or might be witnesses to the investigation that takes place. And we know that it can impact a reputation of a service quite dramatically. Enrolments can drop. It can have a financial impact. But most importantly, the way in which a service responds can reduce the likelihood of another child or the same child being harmed further. So please make sure your policies are updated, and not just that they exist, but they're implemented, that everyone in your service is aware of the policies and that they're willing to and must comply with those policies. Priority 3 is training and communication. Schedule child safety training for all personnel. The government is offering the child safety training that's mandatory, so please be aware of that and look into that if you haven't already. But as I said before, there might need to be other gaps that need to be filled, and you might need to tailor your training. Whether you do that internally or have an external company come in to do that, please be aware that that is an excellent way to mitigate risk. Brief all your staff on the policy changes. Brief all your staff on the changes that have happened in the law that they need to be aware of, including, the personal device prohibitions. This needs to be crystal clear. And if people are breaching your obligations, you need to act on that. It is a serious breach. Update staff handbooks, employment contracts where necessary, and communicate the changes to the family so they understand that policies have been changed and that you take child safety seriously. Priority number 4, systems and records. The National Register needs to be complied with. So if you aren't already complying with that, prepare, make sure that you are complying with it. Collect all the necessary information that's required about your workforce. Do that now. Establish that working with children check monitoring system. Calendar reminders for making sure that you're checking the validity of all the working with children checks. Document all compliance efforts meticulously. It's really, really valuable if there's ever a regulatory inquiry down the track, if you can show that you are doing everything within your power to meet your obligations. And consider seeking jurisdiction-specific legal advice. It is a complex landscape that you're dealing with. You have the national laws, but you also have separate state and territory laws. It is complex. So consider whether or not you want to get separate legal advice in relation to your obligations in each state and territory as well. The key message that I want to convey is systematic, documented, prioritised action. You need to be taking that now. We've already talked about implementation dates, so I'm not going to go over it again. Casey's gone over that already. But I have included up here a slide that really sets out when the implementation dates have already taken place and will take place. So you'll see already that there's a number of things that have already been amended. So make sure that you have complied with that. And if you haven't, please make sure you're taking action now to comply. But you'll see that there's ongoing rollouts of different things and the landscape is constantly changing. So be aware that the laws are changing constantly and understand what your obligations are so you can comply. Legal risk management. We're going to talk about risk from a legal perspective, just briefly. Noting that each state and territory, as I said, has differing obligations in addition to the national laws. So criminal liability risks include failure to report offences. So it's a criminal offence now that if you fail to report physical or sexual abuse within 24 hours, it is a criminal offence. Employing a person without a valid working with children check is a criminal offence. Providing false or misleading information about prohibition notices, that's a new criminal offence. So we've already discussed that and I'm not going to go into it in more detail, but be aware that on top of criminal offences, there are also civil and regulatory risks, including provider approval suspensions or cancellations, which effectively shuts down the business, service approval suspension or cancellation for individual services, quality rating suspension or revocation, which severely impacts marketability, and substantial penalty infringement notices that can run to tens of thousands of dollars. I know here in Victoria, we are seeing the regulator constantly. I think every week we're seeing new regulatory action being taken by the Victorian regulator. So be aware that not only are these things happening, that they're taking it more seriously, but they're also publishing, as Casey said before, they're publishing what organisations or what services are not complying. There are financial risks. Childcare subsidy ineligibility can trigger provider debts that are business threatening. Penalties have increased. Compliance costs and training expenses are unavoidable. Premises modifications, as I said before, may require significant capital investment as well. There's also reputational risks. Enforcement actions are now published publicly. Compliance histories must be displayed at service entrances, and media scrutiny of non-compliance is intense, as you see every day in the media. So there can be a loss of family confidence that can lead to enrolment collapse. I know that in a couple of clients that we're working with, when critical incidents have occurred, you start seeing the enrolment numbers drop off, and that can have a significant impact on the service. Also, a critical point is professional indemnity insurance may not cover intentional non-compliance with child safety laws. So if a provider knowingly fails to comply with harm results, they may find themselves personally exposed. But when we talk about risk, the risk that I cannot ever forget and should not ever forget is the risk to children. And that is why all of these changes have taken place. We know that child safety is paramount. That is embedded in the law. But it's a very practical thing when you've worked with so many children who've been harmed. We do a lot of investigations at Safe Space Legal, and when you see the impact on the children, on the families, on the staff, on the directors who have had to manage and mitigate risk after and whilst it's occurring, it is substantial. So we need to remember that the very reason why these laws have changed is to keep children and young people safe. If we always have that in the background when we're thinking about these really onerous obligations, just remember why they exist. What you don't want is to have a child harmed within your service. What you don't want is to receive a writ, seeking compensation in the millions of dollars. You want to ensure that children are safe. So that is the reason why these laws exist. So I keep going back to that from the outset. I have just included a slide here on essential resources and guidance. There is a lot of information online that the government, different government departments and regulators have produced. It's really helpful, absolutely. So look at that. But if you're still having troubles understanding what your obligations are specific to your service in a specific state or whatever it is, there is help available. So I've got those resources and guidance up there on that slide. So you can take that in. However, if needed, we are available. There's others that work in the area, but we are available. Safe Space Legal, we work exclusively with organisations in child safety and safeguarding. Some of our services include conducting audit and gap analyses of policies and procedures. We can do that against the changes to the legislation. We can do that against the child safe standards, where we can audit what's currently in place and identify gaps. And we can look at that from the perspective of compliance, yes, but we always look at it from the perspective of best practice as well. So we will give you advice, which is legally privileged because we're lawyers, and give you advice on what is best practice and how you can best keep children safe within your service. We draft policies and procedures that are legally compliant. So we do that and we can prepare those for you. A lot of the work we do, unfortunately, is in critical risk management. We do a lot of investigations, including under the reportable conduct scheme. So if you ever find yourself in a position, it doesn't matter how excellent a service is with compliance, how excellent a service is in best practice, unfortunately, these things can and do happen. And as I said before, the way that a service responds to those critical incidents can be absolutely life-changing for both the child involved, but also for the service. So we can assist you with that. We can also do reportable conduct investigations and investigations that are compliant with your legal obligations. We do conduct child safety training, so we tailor our training and we help the service identify where the gaps are, and we can run training with your staff. We can run training with your boards. Sometimes some of the challenges is getting the board on board with what they need to know and understand. So we can certainly do that. And we can do that with all levels of staffing within your service. We also are about to launch Safe Space Training, which will offer an alternative online child safety training modules for staff to complete in different levels as well. So that's about to launch in April. We can also provide discreet legal advice. So if an incident occurs, if something happens where you go, oh, what do I do in this situation? Does this person need to be registered in the National Register? What do I need to do in this particular situation? We can provide that discreet legal advice that occur from time to time. Thank you for your time and attention today. It has been a lot of information. There's been a lot of changes in the sector. We know that, we understand, and we understand how overwhelming that can be. But I want to say thank you for joining us. I know Casey and I, we both love giving this sort of training. We both love going out to services and helping them understand their obligations, because if we can do that from the outset, we can reduce the likelihood of something going wrong in the future. So if anyone needs any advice or assistance, please don't hesitate to reach out. As I said, the government have produced a lot of publications that can assist, and we wish you all the best as you have to adopt these new changes and implement them in your service. Thank you for your time.
Thanks, everyone.